B2B Cambodia, the portal for business use in Cambodia.
You're watching B2B Cambodia's legal update, where we delve into the latest legal changes and developments in Cambodia's laws and regulations. Today, we'll be discussing a key part of intellectual property law in Cambodia focused on trademarks with Ms. Sokun Chanraksmey, Associate at Tilleke Gibbins. It's great to have you here today. Thank you so much for giving us your time.
Thank you.
So for my very first question, could you outline some of the laws and regulations in Cambodia that broadly apply to intellectual property?
In Cambodia, when we talk about the law governing intellectual properties, I would rather say an international law that Cambodia is a party to, like the Agreement on Trade-related Aspect of Intellectual Property, or we call it in short as TRIPS Agreement, and Paris Convention for the Protection of Industrial Property. Separately, for Cambodia, we have different laws that govern different types of intellectual property. For example, we have like the law on marks, trade name, and acts of unfair competition that govern a type of IP. We call it as trademark. And we also have the law on patent, utility models, and industrial design that govern patents and industrial design. And we also have a law on copyright and related rights, and those related rights related to the right of the performer, broadcasting station, stuff like that.
So narrowing down to one of the most common types of intellectual property that I think will be relevant for many businesses here in Cambodia, specifically about registering trademarks, could you explain what exactly is a trademark and what can and cannot be registered as a trademark here?
For me, I think to put it simply, a trademark is a source indicator. So business use it to identify the goods and service in the marketplace. So when consumers see the marks that is used on specific good, they know where that products bearing the mark comes from, which company it's from. So trademark functions like that. They can choose, letters, numerals, words, logo, shape, or combination of those things, or even, combinations of color. Let's use an example like Tilleke Gibbins. It's a combination of words and symbol, right? So it is the trademark used for a law firm to identify a law firm, and it has been registered for legal services in class 45. So under the law, you cannot register a trademark that cannot function as a trademark. For example, if it cannot act as a source indicator, it cannot be registered as trademark. I would, summarize it into 3 reasons what cannot be registered as trademark. First of all, if a trademark describes the good and service it seeks to identify, it cannot be validly registered as trademark. For example, when the trademark is a word and it has a meaning, and that meaning describes the goods that they use for. For example, you want to trademark the word mineral water when you want to, sell, water, pure drinking water. The trademark in that scenario is descriptive, because there are several, type of drinking water in the market under different marks. So if you use, mineral water for drinking water, consumer cannot identify. They cannot distinguish it from the other mark from the other companies, right? So in that sense, such a mark is considered as descriptive. So it cannot describe the good or service it applied for. And on another criteria is that it cannot be misleading with respect to its characteristic. It cannot be, against morality. It cannot be a name of the country, state emblem, and stuff like that. And the last point is that it cannot be identical or confusingly similar to the priorly applied or registered mark in Cambodia.
And can you also explain why it's important for a business to register a trademark?
Actually, trademark right is only obtained through registration. So when you obtain a trademark right, it means that you are provided with an exclusive right to use the mark, meaning that only you can use the trademark. To license that trademark to third party, no one can use your trademark unless you provide consent to. And you can also sell the trademark. It's one of the assets as well. And you can prevent others from using your trademark. For example, if you find anyone who misused your trademark, it could be the same or confusingly similar trademark. You can prevent them from using it. You can also, procedure where you can stop shipment by someone else that infringe your trademark, you can stop that shipment in the border.
And what are the steps that a business needs to take in order to register a trademark? Could you briefly also outline maybe some of the documents that they have to submit?
Business needs to submit an application with the Department of Intellectual Property of the Ministry of Commerce. So in that application, they would need to fill in certain information, for example, their information, who own the mark, who will be the applicant. And after that, they have information about the mark, what mark they want to register, and the information about the goods and services they want to apply for registration. So regarding these types of goods and services, we have the international classification, because there are so many types of goods and services available in our country or in the world, right? So there is this international classification that we based it on. There are a total of 45 classes. So 34 classes contain all types of different goods, and another 16 contain different types of services. For example, like our legal services falls under class 45, restaurant maybe class 43. If you sell clothes, you have to designate for class 25. So that's I know that it's a bit complicated for maybe business when they want to register their trademark. Maybe they don't know what class should we register it for based on our business. Actually, the niche classification that I have just mentioned, you can just check it. It's available, like publicly available. There is a website for that. But I understand that it might be, a bit complicated to see. So that's when business need, legal mark agent to help them figure out based on their business, what the kind of good or service they provide, what kind of class should they register for.
And can you give us an idea of how long it normally takes to register a trademark?
Normally, if there is no objection, for example, when you file the mark application, the examiner at the DIP, the Department of Intellectual Property, will examine the mark. So based on the criteria that I have just mentioned, like what cannot be registered as trademark, for example, descriptiveness. If the examiner does not find that the mark has any problem, like it can be registered, they would allow it for registration, and it takes between 9 months to 1 year. That's the straightforward case.